Katrina Burt, and together with my learned friend Stanley Lees, I appear on behalf of the appellant in this matter, Gandhi. The respondent Mandela is represented by my learned friends opposite, Hussefa Adamali and Chris Browland. This is a hearing of the appeal of Gandhi and Mandela. Would your lordship like to be reminded of the facts of the case?
No, thank you, Counsel.
I am obliged. The appellant will submit that the postal rule does not apply in this case, and therefore no contract was formed, and that Gandhi is entitled to damages because of misrepresentation. My lord, before I move on to the first of my submissions, may I confirm that your lordship has received a copy of the appellant's skeleton argument and the bundle of authorities?
Counsel, yes, I'm obliged, thank you.
My lord, the appellant Gandhi submits that there was not a valid contract until acceptance was received. He will appeal this on 3 grounds. Firstly, that the postal rule does not apply, as this situation can be clearly distinguished from other cases. Acceptance should be a final and unqualified expression of assent to the terms of the offer. It is not disputed that Mandela attempted to accept the offer. However, his acceptance should not be applied in this case. Mandela should have accepted the offer using the same method as the offer was made.
Counsel, can I pause you there for a moment? Your issue about the correct method of responding to the offer, my understanding, forgive me if I've got this wrong, is that a telephone number was included in the advertisement.
Yes.
Is this your point, that the telephone was the correct way of answering it?
Yeah, I'm obliged, Lord. In this situation, previous contact had been done through telephone, and when Gandhi attempted to revoke the offer, this was also done by telephone. In fact, there was nothing within the offer or the previous negotiations that would have given Gandhi the impression that post would have been used. In fact, a reasonable man would have assumed that the telephone would have been used.
Yes, thank you, Counsel.
Okay. My learned friends opposite will argue that according to the postal rule, there was a valid contract between Gandhi and Mandela. The postal rule is an exception to the general rule that acceptance must be communicated to the offerer. However, despite this, the fact that the postal rule has still got precedence in UK law, it has received many criticisms, with Triton describing it as arbitrary and should not be applied in this case. In reality, it would suffice for English law to say that acceptance takes place when acceptance is received by or communicated to the offerer. This position is adopted under many other systems, including the Vienna Convention on Contracts, International Sales of Goods, the Unidroit Principles on International Commercial Contracts, and the Principles of European Contract Law. However, we can also clearly distinguish this case from the leading postal rule case of Adams and Lindsell, which is reported in volume 106 of the English Reports 1818 at page 280. This will be used to support the respondent's argument. In the case of Adams and Lindsell, the previous contacts had been done through the postal service. In this situation, all previous contacts had been done through telephone. This moves me on to my second point. The rest of the dealing had been done by telephone, so it would not be unreasonable for Gandhi to have assumed that acceptance would also be by telephone. The parties need to have contemplated that post would have been used as a method of acceptance. This follows the case of Henthorne and Fraser, which your lordship will find at tab 1, page 7 of your bundle.
Where should I be looking?
At the highlighted area.
The first highlighted section.
First and second.
Thank you, Counsel.
This case clearly states that parties should contemplate whether or not post would be used as a method of acceptance. In this case, prior communication had been performed fully by telephone, so it would not be unreasonable to suggest that Gandhi assumed that Mandela's acceptance would be done through telephone as well. This leads me on to my third point.
Counsel, pausing there. There is a distinction, Counsel, between something being reasonable and something being unforeseen. It's not completely unreasonable, Counsel, to suggest that someone might reply to an advertisement in a newspaper in writing. Is that the submission from the appellant, that that is an unreasonable, unforeseeable course of action?
Your Lordship, we submit that previous contacts had been done by telephone. Gandhi had phoned Mandela in order to make an offer as to the advertisement within the paper. When he attempted to revoke his offer, he also used telephone as his method of communication. In previous cases regarding the postal rule, it was clearly held that previous contact had been through the post, or that a reasonable man would have assumed it. Personally, I feel that if I had previously contacted someone through the telephone, then this is how I would expect them to contact me. This appellant therefore submits that the postal rule should not be applied here. It would be absurd to apply it where Gandhi had clearly wanted to revoke his offer and had taken reasonable steps to do so. Gandhi did not realise that acceptance would be made by post, as Mandela did not express that this is how he would do it. Just because Gandhi did not expressly state that post should not be used, this does not make him irresponsible. He may simply have assumed, which would not have been unreasonable in the circumstances, that Mandela would accept by telephone, as this is how previous conduct had been performed. Just because Mandela was on holiday, this does not mean that he could not have used the telephone to accept the offer. I'm sure your lordship will agree, in today's society of modern technology, it would not be unreasonable to assume that someone, whether they are travelling abroad or within the UK, would actually communicate through telephone, particularly when previous contact had been done in this way. I refer your lordship to the case of Howell Securities Limited and Hughes, which you will find at tab 2, page 19 of your bundle. If you'd like to look at the highlighted evidence. In this case, several exceptions to the postal rule were presented. Firstly, following Henthorne, it was argued that the parties must have contemplated that post would have been used. Also, the rule does not apply if it would lead to manifest absurdity or inconvenience. This means that having regard to all the circumstances, including the subject matter being considered, the rule does not apply where the parties cannot have intended that there should be a binding agreement until the acceptance has been communicated to the other. The same principle can be applied here, as Gandhi did not accept that acceptance would be made by post, and it would not be unreasonable to suggest that either party did not view the contract formed until Gandhi had read the acceptance.
Thank you, Counsel. This idea of producing manifest inconvenience, this manifest inconvenience seems to be levelled highly on the appellant in this case. So it's not simply the appellant attempting to escape from a bad bargain, make a remedy for his inability to manage his own financial affairs. Who should this manifest inconvenience affect?
Your Lordship, this inconvenience affects both the appellant and the respondent in this matter. It also affects the ordinary man. On a daily basis, people respond to small ads, both through newspapers and through the internet. I would ask your Lordship to imagine a situation where he is attempting to purchase an item through one of these small ads. You may view several adverts, and you may send an offer to several people, offering them a lower amount. As an ordinary man, you would not feel bound by these offers. It would be absurd if 3 of those people replied and said that they accepted your offer, if you were to be bound into all 3 of these contracts. It would lead to absurdity if your Lordship was to conclude that everyone who makes these offers on an ordinary daily situation is bound to a rule that they simply do not know exists.
Yes, thank you, Counsel.
Overemphasis, your Lordship, should not be placed on the precise moment that a contract is concluded. The contract in this case did not have a clearly defined duration and evolved as part of negotiations. Putting a rigid offer and acceptance model onto this case does not capture the dynamic nature of such contracts and negotiations between parties. The moment at which the contract was formed should not be overemphasised. The contract formed had a degree of flexibility built into the negotiating format. My Lord, in conclusion, the appellant Gandhi submits that a valid contract was not formed between himself and Mandela, as acceptance was never received and the postal roll should not be applied in this case. Unless I can be of further assistance to your Lordship, those are my submissions.
No, thank you, Counsel.